Hi, everybody. Welcome to Trial Alchemy. And today I'm delighted to have as my guest Eric Traut. Eric Traut is an ABOTA member and he practices law up in Orange County. And he's also a member of the International Society of Barristers. Now, Eric has tried more than 100 civil jury trials in his career, including more than 30 expedited jury trials. Eric represents plaintiffs in personal injury, wrongful death, assault, sexual assault, dog attacks, slip, trip, and fall cases, and vehicle, boat, and plane incidents. Now, Eric has many, many honors, and I'm just going to list a few. This year in 2024, very recently, Eric was selected by all of the Cal ABOTA chapters. I believe there are about 7 to be the Cal ABOTA Trial Lawyer of the Year. Every chapter selects a nominee, and after hearing about the accomplishments, the board selects the recipient, and Eric will be receiving that award later this year in November. Congratulations for that, Eric.
Thank you.
In 2027, Eric will serve as the president of the Orange County Bar Association. He is currently serving as the secretary. Eric was the youngest lawyer to ever receive the Trial Lawyer of the Year award from the Orange County Trial Lawyers Association. Eric's been involved in a lot of different legal organizations, and some of those include he's a past president of the Orange County chapter of ABOTA, the Orange County Trial Lawyers Association, and the Orange County Bar Foundation. And among other honors, Eric has been named in the Best Lawyers in America from 2015 to the present. And he's also been selected as a super lawyer for more than 10 years. So without any further ado, Eric, welcome to the podcast and thanks so much for being a guest today.
I appreciate the invite, Monty, and I'm happy to be here and give any advice and stories that I can about my life as a lawyer.
Well, thanks for doing it. And I'm sure that the folks who listen are going to learn a lot today. So let's start off with this. You've tried a lot of cases, over 100. So what would be an example of one of your most satisfying trial victories that you've had?
One is a recent one. It's a post-COVID trial here in Orange County, and it was satisfying for many reasons, not just the verdict itself. That was, of course, satisfying, but the way I got the case, who I was able to help by getting this verdict. And I can tell you the Reader's Digest version of this case. It was
Sure.
a run-of-the-mill, what it seemed like, rear end accident caused by an Orange County deputy sheriff who was fiddling around with the computer in his car and rear-ended my client. And she ultimately had to have 3 neck surgeries as a result of it.
Wow.
And it was not my case initially. It was the case of a lawyer who rented space from us here in our office, who we had known for over 30 years. His name was Steve Tournay. And about 10 years ago, he got cancer and he struggled to survive. In fact, he was only supposed to live about 5 years. He got throat cancer. They took out parts of his jaw. He was at UCLA months of the year sometimes. But he also had young kids and a loving wife who were dependent upon him and his income and his ability to work. So he came to me about a year before the case was to be tried, and he was having a hard time talking because of the cancer. And he said, I don't think I'm going to be able to try this case. And it's a very wonderful client, righteous case. And the County of Orange is only offering $150,000 to settle this. Her medical expenses are way higher than that. And although they weren't arguing liability, they were arguing that she had pre-existing conditions, she was in her 50s, and that this accident didn't cause her to have these surgeries. So he came to me and he said, look, I'd like you to try this case. And the only promise I want you to make to me is that if you win, which I suspect you will, and if I'm not here when that happens, I want that money that you would have given to me to go to my family, to my wife and kids. Mm-hmm. So I took the case on. I had one of the best clients I've ever had, wonderful lady, very stoic, not a complainer. And we tried the case for 7 days. And I brought in a lawyer who's trying to get a boat of points. His name is Dan Robinson. And many years ago, Mark Robinson, his dad, whose father started Abota, said to me, look, in our practice, we don't get a lot of trials. We do mass tort stuff. And I want Danny to get into Abota. So can you bring him into some of your trials? And so I've done that. He's tried 3 cases with me. He's tried one that I referred to him, and they tried on his own. He's a wonderful lawyer, and he's 1 trial short now of getting the 10 that it takes to get into Abota. So
That's great.
yeah, so that's another backstory to this case. So Dan did a wonderful job. He jumped on board at the last minute with me and tried it. And my son, Connor, it was his first trial. He's only been practicing a few years now, and I had him take on a general damages witness. So after the dust settled, the verdict was 5.2 million and change against the county. Wasn't out of line at all. They did a new trial motion. The judge says it wasn't out of line at all, and she affirmed the decision and rejected their motion, and they ultimately paid in mid-2023. So the gratification I got from that was calling Steve's wife and telling her about the verdict. And in that phone conversation, she told me that I wanted to call you because I knew the trial was starting. It was a date in October of last year. But I wanted to tell you that it was to the day 1 year after Steve's death that you started that trial.
That you started.
Yep.
Wow.
So the day we started the trial was the day he had died a year before. So when they paid, I had her come to the office, and all of the office loved her, loved Steve, and I gave her a check for $500,000. So it was a life changer. It was wonderful and did my heart good, as well as getting this client the compensation that she needed to live the rest of her life more comfortably. She still works, to her credit, but works from home and still has neck issues. And so all in all, it was a really gratifying case to try, and the outcome was wonderful and deserving of this client. The other one is a little bit of a different case. And I've over the years taken very interesting cases, sometimes ones where I'm not real sure. In fact, I'm pretty sure I may never recover any money, but it's the right thing to do, whether it's a small case or it's a case involving maybe changing a law. And that's what this Schrowers versus Roy case was. And this was a case that I tried 2 years ago after battling for several years with this defendant and his lawyer. And this case, in a nutshell, was a Hollywood movie assistant producer who was on numerous sets of big movies, a couple of them involving Johnny Depp, Pirates of the Caribbean. And what this guy was doing was he was setting up cameras in the casting trailer, not cameras, but his laptop, opening up the laptop, leaving the video camera running while the female actresses were coming in to change.
Wow.
He was also, unbeknownst to his wife and family members, setting them up in houses or condominiums or hotel rooms where he was with his sister-in-law and other friends of his wife. He was setting up GoPros in the bathrooms in toiletry bags or trying to conceal them in the bathroom so he could get people using the restroom and taking showers and that sort of thing. And we actually had the film of him in one GoPro where he depicts himself setting up the camera. You could see his face. So there was pretty darn good evidence. And when this case was originally brought to the police department by his wife, who suspected he was having an affair, not that he was doing this, and she went through some of his hard drives while he was on a set in Atlanta and found her sister and her friends and actresses. She's in the movie industry as well. And so she recognized some of these people and brought it to the attention of the Los Angeles Sheriff's Department, who ultimately pressed charges. But the problem with that law, when this was first brought out, which was in or about 2017 or 18, is that you still had a statute of limitations issue. So many of the women who were depicted in these videos couldn't prosecute because their statute had run, even though they didn't know that it was done. It hadn't been discovered. So the date of discovery was not part of the statute.
Wow.
Now it is, thanks to Senator Tom Umberg and others.
Hmm.
The statute has been extended. And part of the reason this case is so wonderful is that the criminal ramifications stemming from video voyeurism has now caught up uh, with these people by imposing stiffer sentences. It's not just a misdemeanor that Mr. Roy pled no contest to, but
Hmm.
literally walked away from. He never did jail time. No other victims brought these cases. So this case was it to go after him. And I
Hmm.
represented the sister and two of the family friends, the ex-wife's friends who were captured on these videos. One of them is a wonderful woman who lives in Africa and works in a school there, donates her time through her church. Just a wonderful lady. So her deposition, her trial testimony was all beamed in from Africa. But I
Wow.
had to spend 5 days trying this case to a defiant defendant who never admitted that he did it. He blamed his wife for wanting to take videos of them having sex in the shower, and she told him to set the cameras up. But the 5 hours worth of tapes that he had no depiction of them ever having sex, had no depiction of his wife. So it was rejected out of hand and ultimately resulted in an $850,000 verdict. He then tried to bankrupt it. And so I fought him in bankruptcy court. And the last hearing was a month ago, where I had to file a motion for summary judgment to dismiss his request to bankrupt the judgment. The other thing that I did in this case, and by the way, I've never collected a penny. I've probably spent over $20,000 in preparing this case for trial,
Easily.
issuing subpoenas, all of that stuff.
Yeah.
But I knew it was such an important case. So now what I've also done is I've sent copies of the judgment, very well detailed written judgment, to every movie studio head in the industry and said, if you ever hire this guy and he does this again and victimizes other women, you are now on notice that this happened. And you're going to be on the hook for any potential damages that these folks have because you ignored my letter. So on the one hand,
Hmm.
I'm sort of ruining his prospects for getting any good jobs and paying this verdict, which is now over $1 million with interest. But I'm preventing him from victimizing other women. And the beauty of these plaintiffs and why they were such wonderful ladies is, of course, I had to run this all by them, and they were instantly giving me a thumbs up. Let them all know, get the word out, do a press release, whatever it takes to prevent him from victimizing other people. And their comment, all of them said, we just feel bad that you're not getting paid. We don't care about not getting paid. It's you that we wanted to get paid in the end and get your costs back. So, that's the sort of thing that once again, makes your heart feel good, is when you have clients like that who are looking more at the big picture and preventing other people from being victimized. So that's the Schrouers versus Roy case. And anybody can look up, it's an interesting case online because you can look up Kevin Roy, Google him, and the stories come up and the press releases come up. And it's an interesting read, but there are a lot of, unfortunately, scary people like Kevin Roy out there who are victimizing people on a daily basis. And with drones, hidden cameras in pens. I mean, you can imagine with the technology now, our laws need to really catch up in every state to these predators.
Boy, those are two great examples. And what it brings to mind to me, Eric, is one of the great things that I think is kind of a blessing or a wonderful opportunity is trial lawyers. You get to make a difference in people's lives. And these are two great examples. One you got paid for, and that's great. You deserved it. But the other one, you haven't seen anything yet, but yet I'll bet you believe you've still gotten paid because you got to make a difference. Is that your feeling?
Oh yeah, even bigger than the Cozy verdict, believe it or not. Even though
Yeah.
it's one of those things that I know it's gonna ultimately help people who would be victimized by him and others down the road, because this judgment has been published as one of the only video voyeur judgments in the state of California, and it'll send a message to anybody who's doing that now, right behind the scenes and victimizing people.
Oh, that's great. So thanks for sharing those. Well, you've tried over 100 cases and you've had, I'm sure, different themes in different cases because you handle a lot of different kinds of injury and death cases. So what are some of the most successful themes that you've used in your jury trials?
Typically, the themes revolve around the client's story because, as you know, as a trial lawyer, you are telling that client's story not just about the incident, what's happened since, but what their life was like before.
Right.
So every case, when I'm preparing it for trial, I do come up with a theme, and it's going to be client based, and based around their life and what they've lost. But I have noticed in one of the ways, and it's not so much a theme more than a method for trying cases on damages, and that is waiving economic damages and getting the jury to focus solely on general damages. And there's a very fine trial lawyer in LA named Wayne McLean. And Wayne McLean's told my brother and I probably over 10 years ago that
Hmm.
he'd been doing that for a while, particularly in cases, catastrophic injury cases where you have maybe $150,000 in expenses or less. Maybe you have $20,000 or $30,000 in lost income, but you know it has seven-figure potential on general damages. And you don't want the jury, first of all, caught up in the economic damage arguments of the defense and why they're minimizing those and attacking those, bringing in billing experts, bringing in people to fight the lost income claim. If it's a lien case where a lot of medicals are on lien, they bring that issue up. Oh, here's the lawyer orchestrating the
Right.
medical treatment, and they've got these on a lien, and we know what's going on here, ladies and gentlemen. It wipes all of that out and it focuses them on what has been lost by this client. And I can tell you, I've done that now in probably 4 to 5 cases just in the last 3 years, and it's been successful in each one. They're not using economic losses as any sort of a gauge. The other thing that it does is it generally tells them that you have somebody who is um, uh, a person who takes care of themselves, they have medical insurance without saying it. Because if you're not presenting the medical bills, then hey, then that's great. They must have medical insurance. That's what they think. The other thing is with the lost income claims. I've talked to jurors afterwards, and they just figure people use their vacation and sick time that they had built up because they didn't need it in the past. They didn't take advantage of their employer on taking paid time off, and they used it to reimburse themselves. So they take that outlook and then translate that into, okay, how is this person's life affected? So to me, that's been a huge and successful sort of theme that I've used and been able to dispense with many of the defense arguments when you do that.
Boy, that's a great strategy. Did you use that one where you got the $5.2 million verdict?
I didn't in that case for two quick reasons. One, it was over $600,000 in
That's a
losses.
lot.
It's a lot. And the other was I had a fine, exemplary orthopedic surgeon, and most of the bills were his. He had never testified in a trial before for anybody in deposition or trial. And it turned out that he was one of the best orthopedic experts that I've ever seen testify. And this was the preparation that I took beforehand. I recognized that when I interviewed him, sort of getting ready for his deposition, and I went, "Oh my gosh, they're going to like this guy, and they're going to give him his bills," and they
Yeah.
did. And in that case, because it was liens, the theme that I used is, look, the defense counsel may get up and say these are liens, and this is a buildup, and this doctor could never get this if he billed insurance companies and that all that malarkey. But you have to remember, he's taking a risk. This is not something he does on a regular basis, but he's taken a big risk because he doesn't know what the jury's going to do. It's
Right.
not that he has an interest in this case. Of course he does, but that's not really what's going on here. He is establishing that he gave her this care. He did 3 surgeries on her. This involves surgery centers and a lot of his time, and he's taken a risk by allowing a jury to decide what his bills should be. And why would you hack and cut away at his bills? So in that case, I didn't, but in a lot of the other cases, and particularly small cases, I want to talk to you a little bit about expedited trials and the themes that are successful in those cases. And the first thing I would like trial lawyers to know is that I'm on a committee, I'm the co-chair for a BOTA of Save Our Juries. And this is a committee that's been around for about 12 or 14 years now in a BOTA.
Right.
And it
Right.
stemmed from numerous studies in federal and state courts that have shown over the last decade plus that the jury system is shrinking. The jury trials are shrinking. There's a lot of reasons for it. That's a subject for another day. But you have judges, particularly in federal courts, who are not that hip on jury trials and are going out of their way to not allow juries to see cases. It's also part and parcel to firms that have partners who don't give cases to juniors and associates who need that trial experience.
Right.
So my pitch for many years, more than 20 years, has been why not try cases, not just junior lawyers, but me. I still try little soft tissue injury cases when I can, because not only does it, in my practice, keep my feet wet and get me up in front of juries. But when I was a young lawyer, it allowed me to see what defense lawyers were doing, what arguments they were making, the tricks that they were pulling,
Right.
motions that I was finding get filed in these cases. And it allowed me to put together succinct arguments, succinct cross-examination, and to try cases where there really wasn't a ton at stake. One of the cases that comes to mind I tried a few years back in Riverside, the R998 offer was $5,000. The defense in that case, Farmers Insurance defense, served one for $2,000. So there was literally $3,000 in between us. And we went to an MSC in Riverside. And I remember the MSC judge coming in and saying, "You're not going to try this case. Just take, maybe I can get him to $3,000. Why would you waste your time?" And gave me this whole speech about why this was the wrong thing to do. And I explained to her, as much as she didn't want to hear it, why I've been doing this for many years and it makes the best business sense. And it also gives you great street credibility with the insurance companies, because when you try a case for over $3,000 in front of a jury, they know that. They know it because their trial lawyers tell them, but also when you publish those verdicts, then they know it and they'll settle those cases. So it actually in the end makes a very good business decision, but it also allows you to really hone your skills as a trial lawyer. So I've tried more than 30 expedited trials, many of them in 2 days or less, a handful of them in 1 day. We tried one through a BOTA that Mike McGuire's office here in Orange County at the time, State Farm, we picked a real trial. And Juan Delgado was the defense lawyer. He's an BOTA lawyer. We tried it in Department 1 in Orange County, and we had 150 people. They were spilling out into the hallway, watching us on closed circuit. And many of them were claims representatives who were skeptical, and other judges who were skeptical about how are they going to complete this trial soup to nuts in 1 day with 2 experts, 3 percipient witnesses, picking the jury, and having jury deliberation. We started at 9, we ended at 4:20 with a verdict. And we got the entire case in. And all of those skeptics, including the claims reps, I think were stunned that we got it done. And it was a good result. You don't have to compromise your presentation. And it doesn't compromise the value of the case, which is much of the worry that plaintiff lawyers have about doing expedited trials. And so putting together that program for a BOTA and now trying these cases in the courtrooms in California has shown the judges that it works, and they love it because now they're getting these cases done in 1 or 2 days, even though they used to be skeptics, and they see how excited the jurors are when they leave that case. Because I can tell you, when I'm picking the jury, we don't have a lot of people raising their hand with cause issues.
Right.
I tell them right out of the chute, my little speech at the beginning is, ladies and gentlemen, this case will be done by tomorrow. I promise you. And we may even get it done by today or tomorrow morning. I promise you. And if you come up with an excuse today as to why you want to get out of sitting in this trial, this judge is going to send you back to jury services. They're going to send you to another courtroom, and I can guarantee you, it ain't going to be this short.
You're
So
going to get a long trial.
yeah. So you see all these blank stares, and they're like, "Oh, okay." And it's remarkable how many times the judge then says, "How many people have a hardship, a legitimate legal hardship that I've just explained to you to get out of your jury service?" Where
Yeah.
I've seen 1 or 2 or no hands go up because
Yeah.
they're like, "Great." And then when they leave at the end of the day or two, they always are happy with the way it went, no matter what the verdict was. They've
Right.
they've served, did their jury service, and so now when they come back for maybe that longer cause trial, they aren't down on the jury system. They aren't searching websites of how to get out of jury service, which is the most searched area on Google when somebody gets a jury service notice. It's
Right.
how do I get out of this? What can
Right.
I say to get out of it? These opportunities, the opportunities that are presented by expedited trials, the reasons why they're so important and good for jurors and lawyers are consequential.
Eric, I've thought since they came out several years ago that you could use expedited trials not just for simple PI cases. You could use it for breach of contract. You could use it for some other kinds of cases. And what you have to do is you have to distill things down to the essence. Of course, that's what you have to do to be effective in any trial.
Yeah.
So how does that hurt anything? So I love this experience that you've had.
And the other thing I will tell you is when I've spoken on this to lawyer groups, including CALA and CAOC, I remind them that even in big cases, as long as you don't have a ton of witnesses and a ton of issues to present on a special verdict form, you can try a wrongful death case. And I know people who have admitted wrongful death cases where the only issue is, what is this case worth?
Right.
You can put that into an expedited format, have your 4 or 5 witnesses, and get a great result. Because one of the fears I always have as a plaintiff lawyer is that I put my case on, say it's a longer case, and so now I put it on for 4 days. The defense puts their case on for another 3 or 4 days. Some of those great people who testified now are sort of at the back of the memory of some jurors because there's been time that's passed. So if you've got them in the moment and now you're a day later arguing a wrongful death case, you may do but much better.
Yeah, I think the primacy is a big deal. They're
Yeah.
going to remember the information you provided faster and better when you're doing it early like that. Well, that's great. And thanks for talking about that. And I think as far as getting more jury trials, expedited trials are a great way for lawyers who haven't tried many cases to try to get some trial experience in front of juries.
Yes.
I mean, they
And
count for a butt of points like anything else.
they do. They count. And I know lawyers who want to try cases, and they mostly defense lawyers who just don't get the opportunity because either the carrier is dictating who tries
Right.
or the firm is dictating who tries them. So, and then one other thing I'll tell you, your initial question was about themes. So one of the
Yeah.
themes that has worked for me over the years in these expedited jury trials, most of them are auto accident cases. So I'll give you that as the starting point. So maybe it's a soft tissue case, chiropractor involved, no long-term care. And so the issues that come up regularly are, the defense themes are, hey, this person didn't call for an ambulance at the scene. In fact, they didn't even go to a doctor for a couple days. Another part of it is they didn't miss much time from work or no time from work.
Right.
They they worked on a lean base, maybe they have gaps in treatment, and they use that as a theme. These gaps in treatment mean they really weren't hurt. And so what I've been able to do over the years is I came up with an argument, and it's called opportunist. And I save it for closing. I don't even mention that word other than maybe in jury selection, that I tell the jury that, look, we're all looking for the opportunist. I get it. You're here thinking that my client probably brought this case because he or she wants more than what they're entitled to. I know that's what a lot of you are thinking. And we're all worried about that opportunist that is the person who is taking advantage of the system.
Right.
And so during the trial, I will, as an example, I'll put the client up and I'll say, now your pain, did it wax and wane? Yes. So were there periods of time when you went to the doctor, there might be a couple weeks or a month where you don't go at all? Yes. And when you were at the scene, you told the other driver you felt fine. Is it the truth? Yeah. Well, so you didn't even start feeling it till later that day, right? And you didn't call me and get me involved for a month or 2 or 6 months after this incident, did you? No, I didn't. And the defense lawyer doesn't see initially where I'm going with all of this. And you went to your family doctor, didn't you? And that doctor, finally sent you, and you had some physical therapy. Yeah. And your work, they accommodated you so you could go back to work. So all of this plays into my argument that I typically save for rebuttal. So I get up and I talk obviously about the case, and this is one of those cases where a lot of times you got to think about waiving the economic losses,
right?
So the lien issues don't come in. But then the defense attorney gets up and says, look, they didn't ask for an ambulance. There wasn't much of an impact. They didn't complain of pain at the scene. They have gaps in treatment. They must not be hurt bad. They didn't miss a lot of time work. All of that. That's the thrust of their theme.
Yep.
So I get up, and I usually put up just on a piece of butcher paper, or when I had an Elmo, and now when I have a PowerPoint, and I'll save that last slide for rebuttal. And I'll say, look, remember I talked to you all about opportunist? Remember those things that should go up as a red flag about what an opportunist is? And I'm going to remind you, that would be the person who asked for an ambulance at the scene. They're thinking, hey, this might be a good money grab. They're complaining of pain instantly and grabbing their neck. They're calling the lawyer right away that they saw on the billboard as they were at the scene. They treated a doctor who treats them consistently. So they have a bill they're there 3 times a week for 6 months, and they run up this giant bill. They sit at home and they eat Doritos and watch TV and don't work, and they take all that time off work. That's the opportunist. That's the person all of us worry about. What happened here? None of that. You have a legitimate, credible person who actually told the defendant they seemed fine at the scene. Didn't call me for months after this accident until they got messed around with by the defendant and couldn't get fair compensation. They treated with their own family doctor, and as we all know, pain waxes and wanes. So they didn't go consistently. And we're just here asking for how this affected their life. That's what we want you to award, not them hitting the lottery like the opportunist thinks that that's what this is all about. So this is the argument that I used in this farmer's case, where we had done a 998 for $5,000, and we did it for $5,000 knowing they wouldn't pay it, because
right.
the adjuster had told me we will never offer more than $2,000 when this 998 runs out, and we're going to go after your client for the costs. So what I loved about this trial is the adjuster was sitting there when the verdict came back. This was in a judge named Atolio's court. It was the first expedited he had ever done in Riverside Court for him. He was a skeptic when it started. You're not getting this case done in 2 days. So after a day and a half, the verdict comes back at $17,000. So they paid all of my costs, which were not great. I keep the costs low, but they paid the verdict within a few weeks. I had a very happy client who didn't mind sitting there for a couple days, and a stunned judge that justice came in a day and a half in this kind of a case.
Boy, that's phenomenal. Now, I don't know if you did that in that case, but whenever you have a situation where you can't get attorney's fees,
yeah,
one strategy you could use, and that could work in expedited cases, is you send some requests for admissions. And if they deny liability and causation, which they typically will, you may be able to get as a kind of a punishment for not admitting those things, attorney's fees as well as other, as part of the damages.
Yes, and I've had that successfully done in 2 of my cases
That's
over the
great.
years. Yeah, where the
Yeah.
judge said this was nonsense that you had to even fight liability here. And
Yeah.
it was nonsense. In the other case I got him, I can remember the defense doctor had admitted injury, just not the extent. So the
Okay.
request for admission saying that your client wasn't injured at all, the judge said that was unreasonable. Your own doctor said that there was an injury. So you're gonna pay some attorney fees. And it's the attorney fees that are elicited from proving up whatever point that is. So if you're proving up liability and damages, that's attorney fees during the entire trial.
Totally. Yeah.
Yeah.
And so that's a great extra sword you can have in those kinds of cases. So good for you. What I love that you've done with both these expedited trials and your argument about the opportunist, and also what you were talking about eliminating the economic damages, is you're taking, and I think any good trial lawyer should try to be doing this, you're taking away potential arguments from the defense, and you're either eliminating them altogether because they can't even make them because the evidence not in play, like with no economic damages, or you're taking the arguments that the defense is going to make and can be pretty persuasive, but you're now giving the jury a different perspective and taking away the power of those arguments. So good work.
That's right. Yeah, and it works. I mean, this opportunist I've used in at least 20 of those trials. And it's funny, the recognition of the jurors when I get up and rebuttal and they start thinking, you can just see it going, yeah, this
Yeah.
person is legit. And even in low impact cases, because those are the toughest. I mean, 7-figure trials where it's just a matter of damages, those are really the easiest cases to try. These little soft tissue cases with
Yeah.
little damage to the car are by far the most difficult cases to win. And that's why a lot of lawyers don't try them when they should. They could get them done in 2 days, get the experience, and get the reputation for trying them. It's
And they
crazy.
keep their chops up.
Yeah.
So you're in the courtroom in front of the jury. Well, let's talk about this. You've tried all these different cases, expedited and regular. So in your experience, Eric, what do you think is the most important part of a jury trial, and why?
There are a couple things. I would say first is jury selection, because you want to make sure that you're having a fair playing field for
Right.
sure. And so I think that's so important. And obviously, I'm not hiring jury consultants in smaller cases, but I'm hitting on the issues that need to be hit and making sure I get a fair group. Because if you start out with a group that's not going to be fair, you're going to lose that case. So I think jury selection is probably number one in my book, but a close second. And this accounts for all trials, but more so on the smaller, low impact, soft tissue cases, is having a likable, credible, and sympathetic plaintiff.
Yeah.
You have to have that, because
Right.
even if you have great facts and a great doctor getting on the stand, everything else sort of falls into play. And you're like, okay, if that missing puzzle piece is a client who's not likable or whiny on the stand, needy, not optimistic at all about their future, you're going to get dinged. That's just been my experience. 9 times out of 10, it's going to be a smaller verdict. They're going to go out of their way to find that they shouldn't get as much compensation if they feel that they're not credible or they just don't like them. And I've learned that the hard way over the years. I certainly haven't won all my trials, and it's most of the time it has been an unlikable client. The jury just went, I just wasn't buying it, or I don't think it affected them that much. There's all
Yeah.
sorts of things. So now what I do when I'm sitting through a deposition with a client, or even actually at the stage of interviewing somebody, I'll make notes about do I want to try this case? Are they going to hit on all those cylinders? And if they don't, and we have a good offer, now I don't hold back on people. And I will tell them, I didn't want to be mean and blunt in the past, but now I will tell them if they're not likable, credible, or sympathetic.
Yeah.
And funny enough, most of the time they will admit it and say, you know what, I get it about myself. They'll have that self-realization already because of things people have told them in the past, and they're not offended by my comments. And I just had this happen literally a couple weeks ago, a case that was coming up for trial, a big offer on the table. And I told the guy, I said, I won't get a third of what they're offering right now if we go to trial. And it's because you're so angry and you can't control it.
Yeah.
And the mediator told him that as well. A mediator named Michael Moorhead, who's great, said, "You're no matter how much Traut can try and fix you on the stand, you're not going to get fixed." And it took him a week to think about it and wrote me an email and said, let's settle the case. But those two things, jury selection and having a likable, credible, sympathetic client, not one that you can mold that way, but who is genuinely that way, those are the most important success items for a jury trial.
Well, I agree with that, especially on the plaintiff side. But you got to have a good, likable client, even if you're on the defense side, because that's going to play into it. But on the plaintiff side, you get to choose. And so I think one of the mistakes the lawyers, when they're younger, make, and I made this when I was younger, you start to get some skills, you start to kind of feel your oats. You think, well, I can clean up that client. Well, hell no, you can't clean up that client. If you don't like him in that first interview, that jury is not going to like him.
Yeah, yeah, it's true.
So those are critical things in trying cases. So in terms of when you're trying to pick the jury, do you like the development in the past few years of the mini opening, and how do you use that when in those few minutes you have to talk to the potential jurors?
Yes, so those are huge. That's a huge tool that you have to say yes to. And it is codified now that the judge has to allow it.
Right.
And some are still, we have a judge here in Orange County who is still poo-pooing it, reluctant, bad mouths it every time lawyers bring it up to him. His name's Richard Lee. And so what he's done is, because the statute doesn't provide how much time you get, he will give lawyers up to 1 minute
Oh
to
my
present a
goodness.
mini opening. That's his way of sticking it to you. But most of the lawyers, or the judges, particularly ones who have tried cases
Right.
in their practice before they took the bench, they will not only allow them, they'll like them. The problem is most lawyers, defense lawyers alike, not just plaintiff lawyers, don't know how to utilize them. And so I spend 3 to 5 minutes, if the judge will let me up to 5. And I spend quite a bit of the time, probably 75% of the time, highlighting the bad facts and pointing out what you know are the potential pitfalls in your case. They're
Right.
going to come out anyway.
Right.
You might as well bring them up now. And it will then end up causing those bad jurors to speak up. I've watched jurors start crossing their arms when I'm doing my mini opening, shaking their heads because I'm bringing up the bad facts.
Right.
And so it allows them to be focused on, it brings them to the surface because they can't control their comments. If you're going to ask for millions of dollars in a case and you have a juror who has these caps determined in their mind,
Yeah.
with mini opening, and you saying, hey, we're going to ask for millions of dollars at the end of this case, it's going to bring that to the discussion right out of the chute. And although some judges are not going to allow you to talk specifics, and I don't really like talking specific dollar amounts, I don't know for sure what I'm going to be asking for in closing. Kind of
Right.
depends on how the case is going to go. But
You want to see how the evidence comes in.
yeah, but you still want to, if it's a 7-figure case, you want to say, I'm going to be asking for millions. So
Yeah.
it will cause those bad jurors to speak up. It also gives you some credibility in your presentation, because the jury will recognize that you're not afraid to talk about and hit those bad facts head on. So I can tell you that I've watched jurors, and particularly in my last trial, when I brought up some bad facts about my client having pre-existing back and neck issues, and findings that were consistent with age-related stuff in her neck and back. And I bring all that stuff up. And then when I do my full opening and I dispel the basis behind some of those bad facts, like she didn't have any symptoms before, you're going to hear that during the course of this case, it becomes more persuasive. It fills in the blanks now with those jurors who are left. So hopefully you've gotten rid of some for cause or had to use a peremptory of the ones who are going to stick it to you on those issues. But now those who even might still have a little question in their mind, now you hammer it home with a full opening and you fill in the blanks with those good facts.
Yep.
And it really gives you credibility because now you've talked about those bad things. And the last thing you want is defense counsel getting up in their mini opening and presenting your bad facts for the first time, because it makes it seem like, oh, the plaintiff, either I didn't know about it or the plaintiff lawyer is hiding something.
Yeah. I mean, you don't want them thinking you're trying to hide stuff.
No.
That's the kiss of death.
Yep.
So that is great. And that's a powerful tool. Let's talk a little bit here about, because this conversation is going quickly. So you've tried a lot of cases since we've come out of COVID. And what has been your experience? Do you think juries are acting differently since we've gone through the COVID pandemic? And if they are, how are they and why do you think they might be?
Well, that's probably a better question for a jury consultant who does a lot of exit interviews, but I can tell you what I've heard and what I've experienced. So my experience is that jurors, and we didn't know it was going to go this way. I think jurors are more open to awarding bigger sums for plaintiffs. And there's been this commentary amongst the lawyers now, plaintiff and defense, called nuclear verdicts since COVID. And I think what's happened is when I've been picking the juries is they are more receptive to the effects of limitations on people's lives because they've just been through it. They've been hamstrung by a pandemic that has prevented them from doing things that they enjoyed in life, whether it's taking trips, going to the gym, all of those things, going to their favorite restaurant, whatever it is. And now they're recognizing the value in that. And I will say, particularly younger jurors, the ex-gens and the folks who we're always worried about because they haven't had the life experiences to really give them a gauge on general damages. Well, now they've been through it. They've lost jobs. They've seen their future get cut by being stuck at home and their goals and aspirations. So I will tell you, I've seen people who are more receptive to staying on as jurors, first of all, and secondly, be more receptive to general damages, which hence I've been more focused on that and trying to not bring up the economic losses and just focus them on life effects.
Okay. I think that makes a lot of sense. And I had another ABOTA lawyer who was two before, well, he's recently been released, his interview, Ken Sigelman from San Diego. He agrees with you. His experience, and he was surprised because he does a lot of med mal cases, but that even in med mal cases, jurors are more willing to find liability against the physician and award more in terms of damages.
Yeah, I didn't know that. That's impressive because we all know that about 8 out of 10 of those trials go down in flames.
Yeah, those are tough trials. Let me ask you this. You're in the middle of the trial and you've given your opening statement, you're doing your direct and cross exam. Some people tend to use one form of cross, which the traditional most common cross is what I'd call the closed cross, where you're controlling the witness, trying to give them only a yes or no answer. And other people like Jerry Spence and other people like him use a much more wide open approach where they're not trying to control them, they're just trying to tell their story. Do you use this similar approach all the time, or do you vary your cross depending upon who you're going after?
I vary it a little bit, but not, I don't allow the wide range of open-ended questions. As an example, with a doctor, there may be a medical term that I
Yep.
want them to explain, and I'll ask that open-ended question. But I am my cross, which I enjoy a lot, is control but nice.
Yeah.
Never cut them off, get in their face. There is one train of thought I think some lawyers have, that if they don't answer it yes or no, and a good expert witness will say, I can't answer that yes or no. May I explain? Sometimes I will say, well, if your lawyer wants you to explain, they can get up and after I'm done questioning, but I'd really like you to answer the question. It is a yes or no question. But if they somehow wiggle in and get into this explanation, I let them
Right.
finish, because I found that jurors don't like witnesses being cut off, and if they feel like you're trying to prevent evidence from getting to them. So I will let them. And then I will say, particularly if I have a good judge who's listening, I'll say, Your Honor, I motion to strike everything after yes or no, or whatever the initial response was, because I asked a yes or no.
Yep.
Motion to strike everything after that. And most of the time, the judges will look at the screen and go, yeah, the motion is granted. Ladies and gentlemen, you will disregard everything this witness said after yes or no, or I can't say yes or no. And once you do that a couple, 3 times, they will stop. And if they don't, then the jury's really not going to like them. But most good witnesses, if they're experts in particular, they
Yep.
will then just answer your questions yes or no. The other thing about cross that I think is important is starting with a very strong point,
Yep.
getting them to admit the strongest part of their testimony for you right out of the chute.
Yep.
Don't let them get comfortable on the stand, and end with a strong point, not with some throwaway question. Start and end strong.
I agree
I think that,
totally.
I think
You got
that's
to
a
do
really
it.
key.
Start strong, end strong.
And the last thing I'll say, and I know a lot of lawyers say that they do this, but then it kills them to sit down. But if I score a big point on something and I'm maybe halfway through my cross, and suddenly they've admitted a very big aspect of my case, I'll say, thank you. That's all I need, doctor. Thank you. And I'll sit down. Even though I have other stuff, end it. Even if it's 10 minutes in, end it.
No, that's great.
And end on a big note, and then you can argue that to the jury later and say, look, I didn't spend an hour cross-examining his doctor. I could have, but once he admitted blah blah blah, what else was there for me to do? You heard
Yeah.
him. I sat
Yeah.
down. Here's all my notes I had ready to go. He admitted blah blah blah. So it's a powerful tool to use. And I also think doing these expedited trials, because you're under time constraints, cross is one of the best things for new lawyers to get their chops wet on, is doing a cross and preparing for an expert witness in an expedited trial.
Yeah, that's great. And the other thing I think you said that was critical is you got to be nice during it. I think the
Yeah.
mistake I made when I was a young lawyer trying my first cases is like I thought of the witness I was crossing as the enemy and I wanted to annihilate them. And I realized, well, the jury's probably not liking that very much, and they don't.
Yeah.
But if you're very pleasant, very professional, but you're controlling them and they're playing games with you, once the jury sees they're doing that, they're not going to like it.
Yeah.
So
Yeah.
that's,
And once the jury feels like they're being evasive and not answering my question straight, you've now completely reversed control to
yep.
yourself, and made that witness unlikable, and they did it to themselves.
Yeah. Well, let me ask you this. We talked about earlier that you will waive the economic damages and you'll often go into trial with just going after the non-economic damages. So when you get to the point where you're making your final argument and you're talking to the jury and trying to give them some way to think about how to put dollars on what your client has suffered through or will suffer through in the future, what kind of analogies or stories do you use to make that something the jury can say, okay, I get it?
Well, it's the first thing I would say is important during the trial to have very good general damages witnesses.
Yep.
And we didn't talk about pre-trial, but I will tell you that's one of the things I do a month or two before trial, yeah, or longer before. In fact, I tell clients at the discovery stage, give me the names of people, coworkers, chaplains, friends, relatives who could describe you before versus after. So first of all, you want to make sure you have those people so you're not having your client up there belly aching or come across that way. You have
Right.
other people talk about it. And so I've summarized, depending on the case, as an example, in the soft tissue injury cases, one of the uh, arguments that I will use is a wanted ad argument. It'll go something like this. I'll just summarize it quickly. I'll say, look,
Yeah.
you've heard the testimony over the last couple of days. Let's assume that Miss Smith, my client, was at home that morning before the defendant ran into her. And she was looking through the wanted ads. And in there was a wanted ad. It said, wanted. Somebody who's going to be on their way to work, stopped at a light, be unaware that they're going to get hit and they're going to get rear-ended. And they're going to have pain that day. It's going to take them out of work for a few days. It's going to cause them to have the inconvenience and pain of going through treatment for a few months, take time out of their day, out of their life, all of their activities they enjoyed doing, and have this nagging pain that they're trying to work through for months after this incident occurs. And for that, we'll give you $15,000 to go through all that. Would Miss Smith answer that ad? I doubt it. Would any of us answer that ad? Now, of course, you can't say to the jury, would any of you violates the golden rule, but you can certainly say, would your client answer that ad, or would any of us answer that ad? And it gets them thinking about that from the standpoint of, no, I wouldn't do that. Why would I? And one of the things in the jury instruction also that I've argued successfully in these smaller cases is the element of general damages of inconvenience. And one of them, this trial I told you about in Riverside, one of the elements of that damage, that verdict, was $1,500 that I argued for someone having to go buy a new car and rent a car and the hassle of it, and not wanting to do that because they liked their car and it was paid for. And the jury admonished me after that trial and said, you didn't ask for enough for the inconvenience damages. You should have asked for more. We would have given it to you, but they gave the $1,500. So that's one, the wanted ad. The others in bigger cases, when you're talking about long-term effects and you have the jury instruction with somebody's, the life tables, the life expectancy tables,
right?
The per diem argument and going back in time and talking about what things cost and translating that into dollars and cents on an hourly or daily basis. We use that very successfully in the $5 million verdict. The jury liked that. And make sure that you add all of it up and you ask for the dollar amount. Because if you just say, I want you to give whatever it is, $80 a day for the next 30 years, the defense lawyer will add it up, get up in closing and say, Mr. Traut, because he knows it's so much money, he couldn't even tell you what it was.
Yeah.
Broke it down into these smaller numbers, $80 a day, because the big number, he should have fear. That's too big of a number. So now I had that happen one time, and that was the last time I ever did that. Now we give them the number, the range.
Yeah.
And it's good to give them ranges. And I think it's also important that you tell them, because they don't obviously have anything when they go back in the jury room other than their life experience to gauge this by.
That's it.
The trial. So I will tell them, the judge read to you that our argument is not evidence. I get it. But you've heard me present this case now for a couple of weeks, and you know that I've been doing this for a long time. And so my advice in this case, I think, is valuable advice and good advice on what the value of this case is. And if you trust me by what I've done in this case, and you find me credible, there is nothing that bars you from taking my suggestion that this is what it's worth. And I'm not giving you these numbers because I'm hoping, I do this in the smaller cases too, I'm not asking for 20 grand, hoping you're going to give me 10. Not at all. I'm asking because I think that's a reasonable number. This is not a negotiation.
Yep.
And that range that I gave you of 18 to 20,000, that's a reasonable number in this case. And you could disregard it, what I said, but I think if you think I'm credible and the case I put on is credible, you'll consider it. And a lot of times I'll have jurors mention that. I'll say, how did you come up with general damages? Well, some of us thought you were a little bit high, but others wanted to give a little bit more. But they talk about it. At least they think about it. And
Yep.
if you've given them a credible presentation, they're going to listen to you. You have to. That's another thing young lawyers need to know. I will never make the mistake again of saying, just do what's fair, everybody. You're the collective conscience of the community.
Yeah.
Because their fairness is oftentimes wrong because they don't know what it's worth. And they come out sometimes, if you make that argument, thinking that their $10,000 verdict is good. They're like happy and think that your client's going to be happy when maybe it should have been 25 or 30,000.
Right.
So you always should give them a number.
You really have to give them something to figure it out with and to help them with that, whatever that is, because they're not given any formula, they're not giving any way to calculate it in the instruction. So yeah, that's a great argument, and that's a great way to do it. Well, Eric, we could talk about trials for another hour, but we're already at the little past the hour mark. So let me just wrap it up today. And my intention with these is to try to help lawyers who haven't tried as many cases as you have, or maybe as I have, and give them some really good information that they can use. So what advice would you give to a young lawyer? Maybe you got this when you were starting out, or maybe you just learned this over the years, but what advice would you give to somebody who wants to become a trial lawyer and hasn't tried any or maybe not many cases?
Yeah, so I've spoken to lawyers about this frequently, mentoring and at my end of court. So the first thing I would do as a young lawyer is I would want them to do their homework on the type of firm that has a good reputation in the community and does trials. And it's easy to find out. You can make some phone calls. You can ask counselors at your law school, because those types of firms are few and far between. And if you start off on the wrong foot in a firm with a bad reputation that's known as a mill or whatever, unethical title, then you're going to always have that on your resume. So that's first and foremost. You should always offer to shadow and assist one of these trial lawyers without being paid for a month or two. Carry the briefcase, watch them in action, ask them if you can help, prepare trial notebooks. Even the most menial things, you should offer to help, because you want to be able to emulate or at least perceive what the proper way is to try a case. The other thing is you should join inns of court in your community. There are always inns of court available. There's great mentoring programs. There's judges. There's other lawyers who do different areas of work, maybe not trial work, family law, criminal defense work. And even without handing out a card over the years, I've had so many cases sent to me by lawyers who just appreciated me for who I was, being at the meeting, talking to people, telling them what I do, and now they are referral sources without me ever having to sell them.
Right.
So go to the inns of court, go to your local trial lawyer organizations, the OCTLAs, the San Diego trial lawyers, the consumer attorneys of San Diego, the consumer attorneys of LA. Even though these people are your competition most of the time, they're also, a lot of them, good people and willing to help you, send you expert depositions, tell you how to approach certain arguments. All of that stuff you need to be a good trial lawyer. And then I think most importantly is join and be involved in charity groups to show that you're willing to give back to the community. You be active in the local bar association, you attend their seminars that teach you how to try a case, but you also get involved in those charity organizations, whether it be Project Youth, whether it be LA Trial Lawyers Charities, Orange County Trial Lawyer Charities. It not only does your heart good, but once again, you doing that and being able to put on your website or telling clients in newsletters that you're helping other people. You're not the the perception sometimes that the general public has that lawyers are greedy and just take.
Right.
Those things are not only the right thing to do, but it helps you in your business of being a trial lawyer, because people like to hire people who give back. And I've found that that's the case because I've been doing it my whole career and spending thousands of dollars and much of my time every month helping these organizations and youth in the community. And it's wonderful.
Well, that's great advice. And I really enjoyed our time and our discussion today, Eric, and you've given a lot of great advice. So thank you so much for all that you do, your charitable work, your work in these different legal organizations, and the outstanding work that you do for your clients. And thanks very much for being a guest today.
Well, Monty, I think what you're doing is great, getting the word out to young lawyers and maybe even seasoned lawyers and giving them good tips through your podcast. So anytime you ever want to have me back again, I'll be happy to come back.
Thank you very much, and we'll end it for now.